Please stand for the prayer, national anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Bayang magiliw, temas ang silanganan, alam ng puso sa titik mo'y buhay. Lupang hinirang, duyan ka ng magiting, sa manlulupit, di ka pasisingil, sa dagat at bundok, sa simoy at sa langit mong baka, may nilang ang tula at awit sa paglayang tinamahan. Ang kisap ng watawat mo'y tagumpay na nagtitigil, ang bituin at araw niya kailan pang may magdidilim. Lupa ng araw ng waraming pagsinta, ay langit sa atin mo. Aming ligaya dapat may mamapit, at mamatay ng dahil sa'yo. Guardians of our rights, enrobed in majesty and light, uphold the fundamental law. From this writ, all their judgments flow. With conscience free their views to air, they vow and wish to all declare, rich or poor, friend or foe alike, God's scales are upon us rise. Justice and equity for all, truth and fairness reign their horn. Stands the fourth of forever Supreme Court. Nation stands on history. Their vision leaves a legacy. For their honor, their faith, their names, the nation will hold on praise. Justice and equity for all, truth and fairness reign their horn. Stands the fourth of forever Supreme Court. Nation stands on history. Their vision leaves a legacy. For their honor, their faith, their names, the nation will hold on praise. For their honor, their faith, their names, the nation
You may now be seated. Your Honors, good morning. Good morning, everyone. This is a public panel interview of candidates for the position of Associate Justice of the Supreme Court of the Philippines. Vice, Your Honor, Lucas P. Bersamin, who was appointed and assumed the position of Chief Justice on November 28, 2018. The panel of interviewers are the following: the Honorable Chief Justice, Lucas P. Bersamin, as ex officio chairperson. Honorable Justice Jose Mendoza, regular member representing the retired members of the Supreme Court. The Honorable Maria Milagros and Fernan Cayosa, regular member representing the Integrated Bar of the Philippines. And the Honorable Judge Toribio Ilaw Jr., regular member representing the private sector. Your Honor, you may now open the public panel interview.
May I just inform the public and the interviewees that I will turn over the chair to the Honorable Justice Mendoza for the rest of the proceedings this morning. And I may be excused. Thank you.
Thank you, Your Honor. Your Honors, the candidates to be interviewed this morning are the following: Court of Appeals Associate Justice Henri John Paul Balinghasay Inting, please rise. And Court of Appeals Associate Justice Joseph Ilardi Lopez. May I request you to stand for the oath? Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth in this panel interview by the Judicial and Bar Council? So help you God. You may now be seated. May I request Justice Lopez to stay in the holding room while the interview of Justice Inting is being conducted. Justice Inting, sir.
Take your seat, please. Attorney Cayosa, you may ask the first questions.
Thank you, Mr. Chair. Good morning, my colleagues, and good morning, Justice Inting.
Morning, Your Honor.
This is the first time that you've applied for the Supreme Court, is it not?
Yes, Your Honor.
And I recall that we interviewed you on July 5, coincidentally together on the same day. You were interviewed with Justice Lopez also, and we extensively interviewed you then. So I just have a few questions.
Yes, Your Honor.
May we know what rank you have in the Court of Appeals now in terms of seniority?
I'm a junior in the 3rd Division.
The number?
Number, I believe I'm 47. I'm not so sure. I'm in that range, 45 to 47.
So definitely
Out of 69.
not among the top 10.
Yes, Your Honor.
What encouraged you to apply at this point, despite the fact that you are not yet a chairman of any division?
Well, it was this way, Your Honor. We had an en banc in Davao, the Court of Appeals, so I met some lawyers there, including the Dean of the College of the Ateneo de Davao. We really didn't discuss anything except that I'm one of the Court of Appeals justices, a Davaoeño. Then lately, I learned that the Dean of Ateneo University, Dean Manny Kibod, uh, endorsed me or gave a nomination letter addressed to the Chief Justice for a position of the Associate Justice of the Supreme Court. So I said, maybe this is an opportunity since I'm already 61 years old and I made a calculation, I'll be senior by sometime August, and I'll be a chairman if I'll be at that time, I'll be a chairman at age of 68. So I don't think time is on my side.
Thank you, Justice. Now, there are many concerns with respect to the administration of justice. What particular idea, process, concept would you introduce in order to ensure the speedy, efficient disposition of cases without sacrificing the quality of resolutions and decisions that are to be issued, especially by the trial courts? We understand, we know that the Supreme Court has supervision over all the courts nationwide.
So, in my experience as a regional trial court, Your Honor,
That and perhaps something that you would want to introduce in order to improve the administration of justice.
well, in my experience, particularly in the Court of Appeals, I have noticed that there are cases like simple offenses, unjust vexation, slight physical injuries that reach all the way to the Court of Appeals. And the penalty even for unjust vexation was like 200 pesos only. So I was wondering why such a case, although it's a criminal case, act, would reach all the way to the Court of Appeals. So I would consider that lawyers should be candid enough with their clients that to learn to accept a decision of a lower court. I think cases reach all the way to the RTC, Court of Appeals, because of some lawyers who are not candid enough to say that they have a losing case.
So would you recommend that those cases, because these are cognizable by the first level courts, that they be appealable only to the RTC? Is that what you are implying?
If it's possible, we trust the wisdom of the RTC judges.
That
Maybe
is-
only if there's really grave abuse of discretion amounting to lack of jurisdiction.
How about with respect to mediation? How do you feel about court annex mediation?
In my experience, there are cases that were successfully mediated. When I was RTC, I even acted as I think it's JRD, wherein the judge acts as a mediator. But if it's not successful, it's referred to another court.
Moving on to another topic, the Supreme Court also regulates the practice of law. Given that we have the mandatory continuing legal education requirements of 36 units every 3 years,
Yes, Your
do you
Honor.
think, number one, that this is sufficient? Number two, that the courses that are required under the MCLE are also warranted? In other words, the number of units that are given to certain topics. And if you were to introduce modifications to the requirement of MCLE, what would it be and why?
Well, in the MCLE, they undergo lectures for certain subjects. But from what I heard, although we are exempted from what I heard from other lawyers, they would suggest that MCLE should be more on a practical side, like more on court appearances to represent indigents. In that way, they will apply the present jurisprudence or everything that is need to be learned by new lawyers, updating in jurisprudence and procedures.
Would that be addressed by the Comprehensive Legal Aid Service already?
In any way, it would only complement, Your Honor, I believe.
Now, you submitted to us a personal data sheet.
Yes, Your
And we
Honor.
required the enumeration of cases that have been, administrative cases that may have been filed against you, whether pending or already resolved, no? Whether in your favor or otherwise. Go ahead. May we know, there were, if you are aware of a certain case, particularly a letter request of William Giuliani.
Yes, Your Honor.
I understand that in your PDS this does not appear. Are
Again,
you
Your-
familiar with this particular case, administrative matter number 1701-01-CA?
Well, what I'm aware is that there were a lot of administrative cases filed against the Court of Appeals Mindanao at the start of my issuance of a TRO against the Ombudsman for the dismissal of Mayor Moreno. And I know I was administered charged together with Justice Camello and Justice Perez. And I believe it was already resolved, and the Supreme Court found no liability upon us. But this Giuliani is not even a party to the case. I remember one time that I need to comment on that letter of Giuliani for a request to investigate the justices like Justice Camello, Justice Perez, Justice Martin, and myself regarding the issuance of TRO. In short, he had a conclusion that there is a TRO for sale in Cagayan de Oro. Together with the three justices, I made a comment. Now, when I filed this PDS, I gave my file. I have my file from MTC to RTC in the house. I brought it to the office. Then these new cases filed against me while in the Court of Appeals Mindanao, I also gave it to my staff for the writing in the column for cases filed against me. I reminded them that I have also cases. I was also included in I don't know if it's really a complaint, but it's a letter request for investigation filed on, I'm not sure now of the month, but it's 2017 when I was already here in Manila. Nevertheless, I got a certification from the court administrator of all cases filed against me. Apparently, that was not also included in their certification. That's why they gave me a call through my staff that I have that case that they were able to misadvertently not include. So I check again my files, and there is that letter request of Mr. Giuliani to investigate us. One of the charges is like we are beholden to the mayor of Cagayan de Oro because we receive allowances, and that apparently in his own thinking that there are TROs for sale, which the Court of Appeals Mindanao has really denied and explained fully well in the comment.
Thank you, Justice. While we note that in IPI number 16-238-CA-J, which was actually resolved together with another complaint filed by William Giuliani, 16-247-CA-J, This one is a separately docketed. So technically, it is a pending
Yes, Your
administrative
Honor, it's
case.
pending. That's why I told my staff yesterday, that is a pending case. I have an administrative case. I'm not really sure if that is an administrative case because it's only a letter request for investigation, to investigate us, but definitely, coming from the OCAD, it's an administrative case. But I made an amended PDS, I submitted yesterday, to be transparent with this council, for this board.
Thank you for the disclosure.
Your
However,
Honor.
that would also mean that unless the case is resolved prior to our voting, it would be considered as a pending regular administrative case since it has been docketed. It has a docket number.
Yes, Your
And
Honor.
that would also render a disqualification. That would, yes.
I would take it that way, but maybe I can appeal to this council that I'm not even a part of that complaint of Giuliani because my participation only, well, can I narrate how it happened? When the ombudsman issued a decision to dismiss Mayor Moreno, almost all of the, I'm sad to say this because they are my colleagues in the courts of Mindanao, they inhibited from accepting the case. I ended up as the last person to accept that case. So I told them, I will not inhibit, but I need a full division. So the two justices who inhibited recalled their inhibition so that a division can function to resolve that case. In short, I issued a TRO because I believe that there was a violation of due process, constitutional right of the Moreno, because he had a comment that was not considered. Meaning to say, the ombudsman said he had no comment, but actually there was a comment filed in another, in the, what you call that, in Cagayan de Oro office, sub-office, which apparently was not considered. So that was my basis. So with that, they filed a administrative case against me and my two colleagues, Justice Camello and Justice Perez. Even for the recall of inhibition, they were also charged. But that administrative case was already dismissed. Now, in the issuance of WPI in the entire case, I was no longer a participant because I was already here in Manila. So if that administrative case is still pending, will be to my detriment, then I submit to your sound discretion.
Thank you, Justice. We will take into consideration the explanation you made today and bring it up to the council when we deliberate on the vacancy.
And may I add, Your Honor, in all honesty, I did not, there was no malice on my part not to include that because this Giuliani has filed a number of cases, like there are a bunch of pink papers. I got already confused which case I was included or which case I am included.
Yes. We confirmed that also, the information from the Office of the Court Administrator. But as I earlier stated, we have extensively interviewed you in July.
Yes, Your Honor.
I still have my notes, and I only wanted to get your comment on the fact that this particular case was not stated in your PDS. And with that explanation, I wish you luck. Thank you.
Your
Thank you,
Honor.
Justice Inting.
Actually, had I known of, I mean, if it didn't muddle my mind about that, I would have a second thought of applying.
Well, it's here. So you're here today, so we will just take the explanation into consideration.
Thank you, Your Honor.
Thank you, Justice Inting, and good luck. Thank you, Mr. Chair.
Thank you, Attorney Chaos. Judge Ilaw.
Thank you, Justice Mendoza. Yes, good morning, Justice Inting.
Good morning, Your Honor.
Yes, I'm going to give you a 30 seconds breathing spell.
Again,
A breathing spell for
Okay.
30 seconds only.
thank you.
All right, are you done? Okay. You're okay now?
Yes, Your Honor.
Okay. How come you remained single?
That's also a question I asked my entire life, Your Honor.
Okay.
Well, after so many years, I'm already in my comfort zone. Well, in college, I had a girlfriend. Then it happened that I had to go to Davao to take up law. Then, so nothing happened out of that relationship. Then in law school, a few relationships, but I'm not saying that the studies got in the way, but maybe for lack of concentration or whatever. So maybe I'm a selfish person in a way that I think first of my own.
Are you happy with that decision?
Yes, I'm happy. I'm here. I'm in the Court of Appeals. I have my family, like my sister Socorro and my brothers, and I have my nephews whom I financially support for their education. So in a way, I'm happy. I'm a fulfilled person in that way, Your Honor.
So obviously, yes, not only happy, but very happy. You don't have a mother-in-law.
Maybe I'll know that if I go through it, Your Honor.
You had been with the Court of Appeals for only 6 years.
6 years, Your Honor.
Why should you be chosen over other applicants who are more senior than you are and have more experience in the Court of Appeals than you do?
That's a given fact, Your Honor. I know that there are more senior members in the Court of Appeals. But I bank on my experience in the government. Like, I've been in the government for 30 years. I was like 9 years in the public attorney's office and more or less 6 years in the Metropolitan Trial Court. And before that, 3 years with the Office of the City Prosecutor. Then RTC for 8 years. I believe that experience would give me a little confidence in applying for this position.
I was thinking not to further belabor the administrative cases filed against you by Attorney Cayosa. I'm just curious that because it appears from, apart from the cases you declared in your PDS, there are still 2 cases filed against you, which you were not declared in your PDS, although dismissed. I'm referring to the cases filed by a certain Benaventura Eje for ignorance of the laws and elementary rules of procedure, grave misconduct, gross incompetence, abuse of authority, and oppression, and by a certain Ramil Lumbre for undue delay in resolving a motion in incompetence in which you were sternly warned. How come these cases are not in your PDS?
I believe they're in my PDS, Your Honor. When I applied for the Court of Appeals, they were included. I will check, Your Honor.
Yes, please.
In fact, I attach all the cases, the decisions and resolutions.
Okay,
In my PDS, Your Honor. Yes.
among the list of candidates, applicants you are applying for, you are top. Yes, please. In my list. Is this a reflection of your character or work ethics?
Again, Your Honor.
You're among the top in my list with having 10, 12, 13 administrative cases. Is this a reflection of your character or work ethics?
Your Honor, if I may say, these cases were filed when I was with the MTC. And knowing the litigants in the MTC, they almost always are disgruntled, and every step of the way, if it's not favorable to them, they would file cases. In my entire stint as an RTC, I had no administrative case. Now, in the CA, I had one or several again because of Mr. Geliani. That was because of the issuance of a TRO. We know very well that the issuance of a TRO is a delicate matter, and you would always say to yourself that you'll be subject to complaints against persons who are not favored by the issuance of the TRO.
All right, there is no quarrel about that because as a magistrate, it's part of the occupational hazard.
Yes, Your Honor.
You are applying for the position vacated by Justice Bersamin, now the Chief Justice.
Yes, Your Honor.
What are your thoughts on his ponencia in Henri versus Sandigan-Bayan?
That he allowed him provisional liberty due to humanitarian reasons and health, Your Honor.
If you were the ponente, would you have decided similarly or differently?
I would agree with Chief Justice Bersamin in his disposition of that case.
Why?
A 90-year-old person deserves just can I get back? Just like a minor, a 15-year-old down, we take into consideration the well-being of the minor. That they need not go to judicial process, they need not be detained or investigated because of their being a minor, which is important for their development. Now, in old people, I think they deserve also that kind of treatment, being not physically healthy anymore, and at their age, twilight years, I think they deserve to be outside the confines of a jail, Your Honor. And as it said, it's for humanitarian reasons.
So the Supreme Court took consideration of the age of Senator Henri,
Yes, Your Honor.
the health condition, as well as he's not a flight risk.
Flight risk, that's true.
Now that Senator Henri is running for senator, we will pay the advertisement with the impression of still healthy. strong despite of being 95 years old. Would your thoughts or opinion be similar again?
Yes, Your Honor, because his intent to run for senator at that age doesn't mean that he's less healthy or less. I mean, okay, I wouldn't say it that way. If he would run for senator, even if he's not healthy anymore and he's already at age 90, then I think that's the effect of his old age. It wouldn't mean that he is less healthy or to give him the benefit of a provisional liberty because of his old age and health, Your Honor. I mean, maybe mentally he thinks that way, but I just think he is not healthy and he's already of twilight years, Your Honor.
And this is the first time you're applying as an Associate Justice of the Supreme Court.
Yes, Your Honor.
So what reforms will you undertake if and when you are nominated and appointed as such to make a substantial contribution not only to the benefit of the bench, bar, and the private sector? Simply your advocacy.
Well, I've been a trial judge since 1998, and the issue really or the problem of trial judges or in the judicial system are it's a docket. So the reform that I would wish to not really enforce, but to as advocacy is the clogging of cases, the poor has access to the judicial system and not intimidating or, in short, available to the poor. Now, when I was RTC judge, it's a one-man job, meaning to say you're all alone with a clerk of court. So you hear cases, you try cases, there are motions to be resolved, there are decisions to be decided within the period. I believe that an additional complement, like 2 lawyers, for a judge to assist him would help in the speedy disposition of cases. Although it will take a lot of budget, but as my experience in the Court of Appeals, I have 4 lawyers and another 2 because I accepted lawyers for an executive assistant. Somehow it helped in the disposition of cases because of their assistance. Now, a trial judge, if he has like 2 lawyers, it would be like a walk in the sun. It would help him concentrate in trial. It would help him in the making of decisions. In that way, a speedy disposition of cases will be attained, Your Honor.
Right. I heard that you were born in Bohol.
No, Your Honor. I was born in Davao del Sur. My father's from Luay, Bohol.
Okay.
But I still consider myself Boholano.
And what do you consider your personal contribution to nation building?
My work ethics as a lawyer. I have done my job uh, honorably and fulfilled my duties as a lawyer. In that way, I think I have contributed to the betterment of this country, Your Honor.
All right, thank you. That was my last and final question, and good luck, Justice.
Thank you, Your Honor.
Thank you. Thank you, Judge Ilaw. Good morning, Justice.
Good morning, Your Honor.
Justice Inting, from your records, it appears that before taking up law, you completed a course in psychology.
Yes, Your Honor.
And
Yes. Yes, Your Honor.
in Davao Hospital, in a Davao Hospital, your profession.
No, Your Honor. Because when I graduated from San Carlos, that was in summer, I went home. Then I took the entrance exam for the College of Law. So immediately after that, I enrolled and I became a full-time student.
In Davao Doctors Hospital, you were only part-time.
Yes, Honor, because one of the professors there, and they needed a teacher to teach psychology subjects, but it was only part-time. I really didn't enjoy teaching at that time. I
And
tried.
You also taught history.
That was when I attended Davao, another colleague. Actually, he was only on leave for a time. Then he asked me if I could teach
Part-time also.
part-time also. Maybe at that time it was to augment my allowances, Your Honor.
I see. As an AB psychologist graduate, how would you define judicial temperament?
Patience, and that with all the power the judge possesses, he must act not indiscriminately and within the bounds of the law, Your Honor.
You were a PAO lawyer for 9 years and then a prosecutor. Which position do you think for you was more fulfilling?
As a PAO lawyer, Your Honor, it was more challenging. That's how I see it.
Can you
Because the
explain?
stacks are all against you. So I enjoyed my stint as a public attorney. I stayed there for 9 years.
You stayed there for 9 years. You were enjoying being a PAO lawyer, helping the poor and the oppressed.
Yes, Your Honor.
And then you decided to go to the other side.
Yes, Your Honor, because my father, he said, you better be a fiscal. As an obedient son, I said, okay, I'll apply as a public prosecutor.
I see. In your PDS, you name here your sister, former Justice Socorro Inting. She is now in the COMELEC.
Yes, Your Honor.
Okay. Uh, are you familiar with the case of National Press Club versus COMELEC?
Again, Your Honor.
National Press Club versus COMELEC.
Not so familiar.
Anyway, I will cite the section of the COMELEC resolution, which was an issue in that case. It was Section 17 of COMELEC Resolution number 9615. The rules and regulations implementing the Fair Election Act, IRR. Two cases have already reached the Supreme Court. One is the National Press Club versus COMELEC. Are you familiar with that?
Not so, Your Honor.
Okay, but you are now applying as an Associate Justice of the Supreme Court. You will be studying and resolving cases in connection with
Election laws, Your
election
Honor.
laws.
Yes, Your Honor.
So, are you familiar with the case of Diocese of Bacolod?
Sadly, no, Your Honor. What I tried to go over was the current issues. The current issues like the case of Cayetano and the case of Loren Lagarda trying to run an office in Antique. So I may have overlooked that, Your Honor.
You will be able to recall this case. This is a case wherein the Diocese of Bacolod placed in their property a tarpaulin,
Tarpaulin.
expressing their position on urging the electorate to vote for the Team Patay, who are pro-RH, and the Team Buhay, the pro-life.
Yes, Your
I
Honor.
remember that.
I read, Your Honor. I'm familiar now.
Also, you are not familiar. It's what
The details I'm not so familiar.
Okay, those are just the details.
Yes, Your Honor.
What? Now you recall the ruling. What was the principal ruling in that case? What was covered? What issue?
That was the Team Patay and Team Buhay. I cannot clearly remember now, Your Honor. I'm sorry. I think it's the expression.
So I'll go to the dispositive portion of the decision, because it is now election time again.
Yes, Your
That's
Honor.
why,
I know.
So this dispositive states that the petition is granted. So it granted the petition of the Diocese of Bacolod. Why do you think the petition of the Diocese of Bacolod was granted?
I think they have the right to express their position, Your Honor.
Is that not a violation of the COMELEC resolution?
Well, the right to express is fundamental, Your Honor. Cannot be curtailed with a resolution. The constitutional right to free expression of your position, even in election.
But in National Press Club, COMELEC, the Supreme Court took a different position. You're not aware of that?
Not
In
really.
that case, the regulation was upheld. In Bacolod, what do you, in National, I'll be specific. National Press Club case involved the prohibition on the sale and donation of space and time for political advertisements.
Yes, Your Honor. Yes.
Limiting political advertisements to COMELEC designated space and time. This was brought by the representatives of mass media and two candidates, and they argued that the prohibition on the sale and donation of space and time for political advertisement is tantamount to censorship, which necessarily infringes on the freedom of candidates. The petition was denied. Now, if a similar case is brought to you, brought to the Supreme Court, you're granting that you have been, that you are now an Associate Justice of the Supreme Court, knowing the pronouncement of the court in National Press Club versus COMELEC and the Diocese of Bacolod versus COMELEC, what will be, if a similar case is brought to you, what will be your position? You can make a distinction and explain.
Well, I think at this time I would allow it, Your Honor, because everyone will have the equal opportunity to be in that situation, Your Honor. The use of a time in the TV to advertise their candidacy.
So your position is that you will uphold the regulation?
Yes, Your Honor.
Yeah. Despite the pronouncements in Bacolod?
Well, in Bacolod is more of the right to express their sentiments, but in this case, it's just a vehicle in expressing their, allowing them to forward their campaign, Your Honor.
What are the other distinctions? Because you are familiar with this Bacolod, there were distinctions. With the Diocese of Bacolod case, there were distinctions made by the court regarding National Press Club versus COMELEC and Bacolod. If you can only recall.
I have a hard time recalling, Your Honor. I'm sorry.
Anyway, when you reach the Supreme Court, you will be inhibiting maybe because your sister is there.
As I remember her saying that she's not familiar, when she got appointed, she said, I'm not familiar with election laws, but she is a fast learner. That's what she said.
And you're also a fast learner like her.
That's what I want to believe, Your Honor.
There is a pending bill now recommending the lowering of social responsibility to 12. What is your view on that? Are you familiar with the bill?
Yes, Your Honor. HB 8588, I believe.
Yes.
It's to lower the age of criminal, they don't want to call it criminal liability, but criminal responsibility.
Yes,
Lowering it.
I said that.
Yes, they want to lower it to,
Social responsibility.
yes, they want to lower it, not at first at 9 years old, then to 12 years old. It's like going back to the revised penal code where the person, the minor who is exempt is 9 years below, 9 years up, 9 years over to 15, if with discernment. So if a minor at 9 years old at the time, like 1930s, 40s, are considered minors who may have the capacity to distinguish between what is right and wrong, with more reason that 9 years old or 12 years old youth now who are exposed to the technology of the internet, Facebook, everything. They are aware of what's happening. They know what's going on. I think, I believe, to lower it at 12 is, it would be the right thing to do. Because in the 9344 Pangilinan Law, they enacted that law in reaction to the situation where the youth, minors, are lumped together with hardened criminals, and they go through the process of the judicial process, like going to court together with hardened criminals. So, aside from improving the program of rehabilitation, they want to veer away the child from judicial process by increasing from 9 to 15. So if you're 15 down, who has committed a crime, they're exempt. They don't have to go through the process of the criminal procedure. They will be brought straight to intervention and rehabilitation. But the setback, what happens now are, there are youths now, or the youthful offenders are not only committing petty crimes. What are being committed now are serious crimes like murder, rape, and even drug-related crimes. So I think there must be something that must be done to that. So to lower it to 12 would make the youth aware that there are things that are criminal acts. They should know that there are things that are criminal acts, and they should be answerable for that. But they'll be aware of a criminal act, but they will not suffer like imprisonment, because there are interventions and rehabilitations. But the fact must remain that they should know that what they have done is a criminal act. Even if they're just called a child in conflict of the law, they should know that what they have done is a criminal act, because there are victims.
They should be reminded, being a PAO lawyer,
Yes, Your Honor.
being a former PAO lawyer and former prosecutor, do you believe that lowering the age will deter or reduce the crime rate in the Philippines regarding those covered by that bracket, age bracket?
It may not reduce, Your Honor, but maybe the seriousness of the crime, the type of crime that may be committed, may be diminished. Like it's a fact that some minors or youths are being used by criminal syndicates in the commission of a crime, with the belief that the minor will not be incarcerated or whatever.
Personally, in your experience as when you were a PAO lawyer or even as a prosecutor, did you handle cases regarding minors?
Yes, Your Honor, for simple crimes like, in fact, they were only housed in the Mulabe Youth in Quezon City, Mulabe Youth Center.
They were not charged criminally.
Again, Your Honor?
They were not charged criminally. They were your clients as PAO lawyer.
Yes, Your Honor.
They were not charged criminally.
Those are under the revised penal code then, which is like 9 over 9 up to 15 when they acted with discernment. Yes, Your Honor.
Not yet.
Because when this Pangilinan law was enacted. It was, I think, 2006. I was already a RTC, and there are family courts. And these cases do not reach the courts because they are
Now,
brought to the DSWD for intervention and whatever. Cases of minors only reach when they are the victims, Your Honor.
that is under the present laws.
Yes, Your Honor.
Now, in your experience, do you believe that children, even 9 years old, they know right from wrong? They can.
Yes, Your Honor. I didn't get that.
Oh, yung about age 9.
Yes, Your Honor.
Do you agree that they already know what is right and what is wrong?
Yes, Your Honor. They know what's right or wrong, but maybe the degree of what they have done, they may not be aware, Your Honor.
And also the consequences, legal consequences.
Yes, Your Honor.
You mentioned earlier that you are now in your comfort zone, and in the Court of Appeals you found fulfillment.
Yes, Your Honor.
So, but you want to get out of that comfort zone. I'm not referring to your social standing in the Court of Appeals.
Going
You
to
want
the Supreme
go
Court.
to the Supreme Court.
Well, that's the biggest dream of a lawyer, Your Honor, to be in the august halls of the Supreme Court.
So, your dreams have not yet been fulfilled.
Yes, Your Honor, in that way.
That would be all justice. Thank you very much.
Thank you, Your Honor. Maybe I excuse now?
Excuse, your excuse.
Can I approach the bench to shake your hands, to give me confidence?
Thank you, Justice Inting. Your Honors, the next candidate to be interviewed this morning is Court of Appeals Associate Justice Joseph Ilarde Lopez.
Good morning, Justice Lopez.
Morning po, Your Honors.
Will be first question by Attorney Cayosa. Attorney Cayosa.
Ayos, sir.
Thank you, Justice Mendoza. Good morning, Justice Lopez.
Morning po.
Yes, we On the same day that we interviewed now Justice Inting, we also interviewed you for the position of Court of Appeals. That was in July 2011. So by coincidence, you are both here today. Anyway, I have a few, just a few questions since, as I stated, we interviewed you previously in July of 2011 when you applied for the position of Court of Appeals Associate Justice. First of all, we received a copy of the information from the Reporters Division of the Court of Appeals, and among the contenders today, you have the highest case disposal of 1,431 cases for the past 4 years of your stint as Associate Justice of the Court of Appeals. So congratulations on that.
Thank you, ma'am.
Okay. I would just like to know what your thoughts are with respect to the conduct of MCLE. I noted that you do conduct lectures for the mandatory continuing legal education.
But-
Do you think that there is a need to modify the requirements, no? Particularly the subjects that are required for the compliance, for the issuance of a compliance certificate?
I'm not really into lecturing in MCLE. It's a limited stint only because the Dean of New Era College of Law invited me to give lectures at the New Era College of Law. But it's open to all lawyers. From what I know, lawyers find it interesting to attend MCLE lectures, especially when it comes to updating on their knowledge of the recent jurisprudence and recent laws. So that is as far as I know, Your Honor.
So you cannot say whether there is a need for us to re-examine the subject requirements, no, for the units to be earned.
I think there are many units on legal ethics. I think it should be retained. Constitutional law and civil law. I think more or less I agree with the number of units assigned to each subject, Your Honor.
And on another note, with respect to the administration of justice, you were a prosecutor for a long time, and I'm sure you're familiar with the criminal justice system. Some of whom, there are those who feel that it's still a slow process. What would you recommend, should you be appointed to the Supreme Court, that would help hasten the administration and of justice and the resolution of cases, taking into consideration that there is already continuous trial and all of these reforms? What would you add as a suggestion, or a comment, or a proposal?
There was a time I was invited to discuss on how to shorten the period of resolution of cases before the DOJ. And I think there were some suggestion to limit the number of days for the resolution of the cases pending before the DOJ. So instead of filing an MR, they can appeal right away. If the case has been decided by the local DOJ or the city prosecutor's office at the local level, there should be no more MR, and it should be appealed right away to the DOJ for the secretary to resolve the case. And should the DOJ secretary should resolve the appeal, then it must not be appealed anymore to the Court of Appeals. This is in a way to shorten the time to resolve preliminary investigation cases. So instead of taking so long a time just to resolve preliminary investigation at the level of the DOJ, it should be brought up to the court for the court to determine also if there is probable cause or no.
There is a proposal in Congress for the investigating prosecutor also be the prosecuting fiscal when the case goes to trial. Are you in agreement with that proposal, and why?
Yeah, it could be done because they are already familiar with the facts of the case. So they would right away know whether there's probable cause and what will be the evidence to be presented before the trial judge. The issue then at that time was when we had this seminar in Boracay was whether or not the prosecutor will have to conduct the preliminary investigation or leave it to the judge to conduct preliminary investigation at his level to see if there is probable cause. But that, I think, would be too taxing on the part of the judge.
Wouldn't having the determination of probable cause be an added layer where if we were to follow that proposal, the determination be done in court so that they can issue the proper orders so that the case can proceed?
Well, anyway, so instead of the DOJ conducting the preliminary investigation to find out if there is probable cause before filing the case in court, the judge will do some sort of preliminary investigation. Anyway, the judge are doing it right now. They determine probable cause to whether or not to issue the warrant of arrest. And if there is no probable cause, the judge on his own can dismiss the case. So that might also be one possible way to shorten the cases before the trial courts.
Thank you, Justice. We take this interview as an opportunity to allow the applicant to address issues that may be raised with respect to their application or
Yes, ma'am.
nomination. So you submitted a personal data sheet which was dated January 28, 2019. And we required the enumeration of administrative cases. We noted that the certification from the Office of the Court Administrator stated one case which we could not find in your PDS. This was the case filed by Rolando Faustino, while this was dismissed in October 2012. This is under AC number 9641. We did not find it anywhere in your PDS. Could you tell us why?
Yes, ma'am. I was informed about it only through a letter by the council secretariat that there is such a case, Faustino versus Jhosep Y. Lopez. I think the name itself strongly spelled, but I'm not sure if I am the one indicated in that complaint. But we tried to ask the court administrator's office if there is such a complaint, because we do not have in our files the record of such case. But we're still exerting effort to this day. I asked my staff to find out, even my staff at the Office of the City Prosecutor, to find out if there was really a case filed by a certain Faustino.
This is an administrative case pending now with the, resolved by the Supreme Court.
This was already dismissed
Yes.
by the Supreme Court, but I did not receive a copy of the complaint, and I was not asked to file a comment to the complaint. And as far as I know, and as far as I can remember, I have not received a copy of the Supreme Court resolution dismissing the case. But just the same, I'm thankful that the Supreme Court, from the information given, has already dismissed the case.
On another point, you submitted to us your SAL-N and also your income tax returns,
Yes, ma'am.
as well as you made declarations of your bank accounts. So we were just wondering why there is a difference from what was issued by the bank, certified as of December 31, 2018, particularly in BDO. There is apparently a difference of 2.5 M in the balance. Well, you might want to look into your records further, but we will also require you to,
Yes, ma'am.
to submit
I
a comment, no? Should you wish to do so.
think there is a difference of 500,000.
And can you explain that?
Yeah, it was a mistake on my part because I indicated in the PDS a certain amount, but apparently what was typewritten on the PDS is an amount a little more than what should be indicated. So it was my fault. I just went over it a few days ago, and it was a mistake on my part. So I'm going to write the council to explain about the disparity in the amount.
Thank you, Justice. And you also submitted to us your SALN from 2008 to 2017. And in 2008, your declaration for cash in bank was 1.6 M. In 2009, this went up to 2.850 M. In 2010, this went up to 5.5 M. We were just wondering, since you were, I think, a prosecutor at the time, and the only visible source of income was your income generated as a prosecutor. In your SALN, nowhere was it stated also that you were engaged in any financial or business interests. So could you explain to us how these amounts, increased through the 3 years?
Well, first, I'm based on the record also that I've submitted. I'm single, so I've not been spending any money. I've not been going abroad, or I have not been spending so much money extravagantly. So I was able to save a lot of money, and based on interest, probably I could have earned more or less some amount of money for that period of time.
But if we take into consideration the income that you stated in your ITR at the time, it would still be sort of not proportionate to the increase. So we will also give you an opportunity to respond to this, but you might want to look into this, because we find it rather, in fact we have a graphical representation, and you will see that there's a spike.
For that period alone?
Yes, for this
I'll
period
try
alone,
to see,
so
because
there is a spike. So we do a comparative study, and we would like to give you an opportunity to explain this as well.
there was a period of time when I was the city prosecutor. I engaged in some form of business. It's loaning money, but it did not last long.
But this was not declared in your SALN? And
Eh,
it was not declared also as part of your income, since...
But it's actually given to my relatives, the loan given to my relatives.
But if that were the case, then this would actually form not as cash, but more of collectibles. But it
Well, I'll try
wasn't
to check again on it, ma'am, and
Yes,
I'll be able to explain it in writing. I'll submit it to the council at the soonest possible time.
Okay. Thank you,
Yes,
Justice
ma'am.
Lopez.
Thank you, ma'am.
That's all. So
Thank
with
you.
that, I wish you luck. Thank you.
Thank you.
Thank you, Justice.
Thank you, Your
Mendoza.
Honor.
Thank you, Attorney Cayosa. Judge Silao.
Yes, thank you, Mr. Chair. Yes, good morning,
Morning, Your
Justice
Honor.
Lopez. You're also called Jolo,
Yes,
not
sir.
Jologs.
Not that I know, but some people call me Jologs.
And,
But it should be Jolo.
okay. Sorry, belated happy birthday.
Yes, sir.
That was when February.
February 8, Your Honor.
Okay. What was your birthday wish?
Well, my birthday wish is to be able to make it to the Supreme Court, but just a birthday wish, Your Honor.
Another one, still a bachelor despite being. How young are you now? That's 56.
I'm 56.
I will not ask you the reason why you're still single.
Well,
You
it's
may have
not,
been given a tip by the
it's
previous question to another applicant.
it's not really a matter of choice, because I tried to look for one permanent partner in life, but I was not lucky to be able to find one. But I'm not hopeless. Yes, yet at this point. Probably in the next couple of years, I might be able to find one. But if ever that fate would have it that I stay single, I think I would consider it as God's given single blessedness, Your Honor.
Right, you have so many memberships in various organizations. As a magistrate, do you consider having so many friends and acquaintances from various organizations a curse or a blessing?
I have many organizations because for a time I was involved in politics. But from the time I was appointed to the judiciary, as much as possible, I tried to avoid attending all these meetings of the organization. So, but I maintain my membership, but normally I do not attend the regular meetings already, just to avoid any contact with any private individuals who might be interested in some of the cases I handle in the court. So far, none that I know from friends from the organization that I've been with tried to convince me one way or the other, Your Honor.
You mentioned about avoiding any social acquaintances.
Yes, Your Honor.
How important is judicial ethics in the performance of the duties and functions of a magistrate and in the administration of justice in the country?
Judicial ethics is very important, especially for those in the appellate court, because as we all know, judges must not only be fair, but they must also appear to be fair. So unless people think otherwise, you lose your credibility, not because you are actually involved in any kind of anomaly, but you appear not to be fair and just.
Correct, there is an opposition and an undated and unsigned negative feedback alleging corruption in the 15th Division of the Court of Appeals, resolving appeals that were paid to be resolved and not resolving cases that were paid not to be resolved, to avoid execution of judgment against paying litigants. You commented that
yes, Your Honor.
dated that January 29, 2019.
It was an anonymous letter, and it refers to the time when I was with the 15th Division. That was when I was with the 15th Division. I think it covers the period from March to October of 2015 or 2017, Your Honor. And during that time, if I may say, for that whole 1 year, 2017, I came out on top of the list of all justices who was able to resolve the most number of cases in the Court of Appeals. So I beg to disagree with that content of that anonymous letter, that we try to resolve cases only when there are some as alleged by the person supposedly who wrote the letter, we give priorities to some of the cases. It's not true, because we base our decisions, or we give priority to decisions based on the rules we have under the rules of procedure in the Court of Appeals. So if in civil cases, only in instances where there are TROs, or preliminary injunctions issued, otherwise it should be based, the older cases should be given priority. And the same thing with criminal cases. We give priority only to cases where the accused is under detention. So we strictly observe these rules that we have in the Court of Appeals, and I do not see any anything that from which we have digressed from that provision of law. Of course, I cannot speak for the other members of my division at that time, but I can vouch also for their integrity, and I don't think there is any truth to that allegation, and that is precisely why they are the one who wrote it was only did not indicate his name in the anonymous letter that was circulated in the Court of Appeals. In all probability, he must be one of those disgruntled parties who have lost the case before us, Your Honor.
All right, there was also a case filed against you for alleged corruption and extortion by a certain Dolora Cadiz Cana. Another one for violation of Republic Act 3019 anti-graft law by a certain Reynaldo Bagaching. Now, do you believe that there is corruption in the judiciary?
If I may explain first, Your Honor, with regard to the Bagaching complaint, it was during the time I was City Councilor of Manila, so it does not have to do with the judiciary. It was not during my stint as member of the appellate court. It was filed long time ago, Your Honor, as a councilor, and the respondents then were all the councilors because we passed a law transferring one public school from one site to another site for many reasons. And in fact, the case was already dismissed because I was not even one of the signatories to that resolution, Your Honor.
Yes, I understand it was already dismissed. But,
Yes, Your Honor.
Going back to the question, do you believe that there is a corruption in the judiciary?
There could be, Your Honor, but I don't think it is as rampant as some people would like to portray it. I would like to believe that, especially at the Court of Appeals, the justices appear to be decent, and they would not they decide the cases based on the merits of the case. Otherwise, the decision itself would show itself if something is wrong about the decision.
So what measures would you propose to minimize, if not to eliminate, the alleged problem?
The appearance before the public is very important, Your Honor. So I think the justices should not be commingling with many of the lawyers, especially those lawyers who have pending cases with the court, Your Honor.
You stated in your application letter that during your stint as Manila City Chief Prosecutor, you successfully initiated a number of significant reforms to ensure efficiency and integrity of the office. You mentioned the computerization of your office records. How did you make that happen?
Well, with the help of then Secretary of DOJ, we were provided with so many computer sets, and with the availability of internet, we were able to monitor the case. And this is one way of discouraging corruption at our level, because we monitor the cases, when was it filed, when was the hearing, when was it resolved. So they must comply with the number of days that they have to resolve the cases. Sometimes when you wait for a longer period of time to resolve the cases, that is one way of enticing or inviting the parties to talk to the fiscals. So we make it sure that the cases filed before the prosecutor's office are resolved on time, so that there is no way that the parties might be able to make contact with the prosecutors.
Have you penned a decision that was contrary to your personal moral belief?
None that I remember of, Your Honor, but more or less everything is based on what the law provides, Your Honor.
What did you learn about yourself from your 6 years in the Court of Appeals?
Well, legally, I've learned many things because for 7 years,
For yourself? Okay, so sorry to interrupt.
yes, for 7 years, I've been city prosecutor. More or less, I've been concentrated on criminal cases, but in the Court of Appeals, we have been resolving all kinds of cases, from civil to special proceeding and so on and so forth. Although, in the past 20 years or so, I have also been teaching in law schools, and I've been teaching different subjects in different law schools all at the same time, Your Honor. Just to update me on the... Sorry, sir.
What is something that no one would ever guess about you?
No one could guess about me. Well,
Something with you?
what they see is what they get from me. I don't think I have anything to hide from anybody. So my story and my history and my career is an open book.
All right. Could you choose a current event topic and share with us your thoughts thereon? Just for example, the legal effects of changing the name of our country. DBM Secretary Jokno be cited in contempt.
Well, with regard to Secretary Jokno being threatened to be cited in contempt, I'm not totally agreeable to it because there are under the Constitution, Section 21 deals with inquiry in aid of legislation. And if the party fails to comply with the notice of hearing by the committee of either Senate or Congress, then he might be cited in contempt. But under Section 21 of the Section 22, it's about question hour. It's the right of the President through the cabinet secretaries to attend and inform the body about the implementation of a certain law. And in this case, the Secretary Jokno was invited to shed light on the law that they're supposed to pass, which is the budget law. But I don't think they have the power to cite him in contempt or to compel him to attend, since this is a question hour and they do not have the right to compel attendance, as differentiated from Section 21, which is a inquiry in aid of legislation, Your Honor.
All right, that was my last and final question. Thank you.
Thank you, Your Honor.
And good luck to your journey as
Thank
a
you,
traveler.
Your
As a traveler.
Thank you, Your Honor.
Okay, thank you, Judge Silao. Good morning, Justice Lopez.
Good morning, Your Honor.
You mentioned earlier that one of the reforms that you want to introduce is that you limit the appeals in preliminary investigation to the level of the Department of Justice only. Am I correct? You propose that there should be a limit?
Yes, Your Honor, but of course we have under the Constitution abuse of discretion, which could be brought to the court on the basis of abuse of discretion, Your Honor.
So it's very difficult to...
Yes, but probably by some changes in the Constitution and the law, we should limit not only appeals with regard to preliminary investigation results, but also with cases in the lower level courts. So instead of having it appealed to the highest court in the land, we put a stop at the middle level, Your Honor. if that would be possible under the present setup. If not, then we have to change the Constitution.
Yes, because we cannot do away with the provision on judicial review.
Yes, Your Honor, because it's included in the Constitution under judicial review, not only actual controversies, but also those involving abuse of discretion, Your Honor.
So you cannot really legislate that the decision of the DOJ in appeal cases be considered final.
Yes, Your Honor, but probably they could limit the number of days wherein MR and preliminary investigation could be limited, Your Honor.
Maybe they could state that it is final at that level because it is executive,
Yes, Your Honor.
and a petition for review or a petition for certiorari before the Court of Appeals is the first judicial step. Do you agree?
Yes, Your Honor.
You submitted an explanation regarding the complaint that you have a very high case load. In fact, it was shown attached to your
Explanation, Your Honor.
explanation that you have 326 pending cases as of December 2017. And you explained that you followed the order of priority or the
Yes.
process of adjudication.
Yes, Your Honor.
Well, since you followed that law, the rules in the Court of Appeals, you followed that and you ended up being number one. You have the highest.
Yes,
Yeah,
as far
what
as
do
I
you-
know, it's for the year 2017.
Yes,
It's just now
17.
I was
Yes.
informed that I came out on top for the last 4 years.
Oh, very good. Do you have any suggestion regarding the rule on the process of adjudication to help the other justices, or does it need tweaking? The rule you quoted.
As it stands right now, I think it's there could no better rule as of now. Many justices have been doing better than before because of the monitoring. The computerization is one way of making sure that justices comply with the mandatory period of time within which to resolve the cases, Your Honor.
It's your position that the status quo be preserved or maintained.
Of course, there are some provisions that need changes because, like extension of period of time to file should be a memo, or extension of time to file comment should be limited to such an extent that we should not be too liberal about it, just to make sure that the parties comply with the periods of time within which to file the necessary pleadings, Your Honor.
But the rule is still discretionary.
Yes,
You
discretionary.
can extend depending upon the reason.
Yes, as of now it stands.
You cannot really put an absolute limit.
Yes, I agree, Your Honor.
Now, you are an MCLE lecturer on criminal law, is that right?
Yes, criminal law and criminal procedure.
You're familiar with the case of People versus Romilim?
Yes, Your Honor. That was lectured on us by Justice Peralta when we had a sort of seminar in Subic a few months ago.
Suppose a case is brought before you, a petition, granting that you're already a member of the Supreme Court. A case was brought to you, calling for praying for a review or revisiting the pronouncement in People versus Romilim. What will be your position?
Well, from at to revisit or to change the principle that was that had been adopted that has been adopted in that case might not be necessary. In fact, the ruling in that case should be applied prospectively from the administrative matters issued by the court. So
Yes, in the clarification, it was stated that it should be applied prospectively.
indication.
But then, what I was asking earlier was the situation wherein they're asking you to review the ruling there because Section 21 had been amended and it says that non-compliance is not actually fatal. You agree with that? You remember that amendment?
Yes, Your Honor. There was an amendment to that Section 21. Instead of requiring all three parties, meaning the DOJ representative, the media, and the barangay officer should be around to attest or to witness the inventory of the drugs. Right now, under the amended law, what is required only is the presence of the DOJ and the media or barangay representative. Or I think I got it wrong. I think it should be the barangay official and the DOJ or the media representative, Your Honor. And during earlier rulings, there could be justification provided by the police officers who apprehended the accused. They could justify why they were not able to strictly comply with the requirements of Section 21. And even then, if they could not justify it, as long as they could show that the integrity of the drugs has not been compromised, then they might still be able to present the same drugs as evidence in court without question on its admissibility, Your Honor.
They failed to explain their non-compliance in writing. Do you agree that the prosecution witnesses should be allowed to explain when they are placed on the witness stand?
The ruling in the Romilim case requires the prosecutor to do, if there was no explanation, to require the parties concerned to explain it in writing. And if before the judge the same is filed and there was no such explanation, the judge may also require them to explain it in writing, Your Honor. That is as far as I can remember, Your Honor.
You are presently the chairman of the Court of Appeals Bids and Awards Committee, right?
Yes, Your Honor.
What is the general mode of procurement? You know, because you are aspiring to be a member of the Supreme Court. Most cases from the Ombudsman cases, in administrative cases, they go to the Court of Appeals, the petition. In criminal cases, they go to the Supreme Court. Usually the cases involved are violations of the procurement law. What is the general rule on the methods of procurement?
Procurement should be by public bidding, and although I must admit I'm not very familiar with the rules on public bidding. We have lawyers assisting us on the rules and requirements on public bidding, but I see to it that these rules are complied with every time we do public bidding, and there is the bid must be opened in public, meaning it's open to all the parties concerned, and even to third parties who might be interested to see that the bidding at our level, at the Court of Appeals is open, fair, and just, Your Honor.
How many years have you been a member or chairman of the Bids and Awards Committee?
Very recently only, Your Honor. Not even a year, probably 6 months, Your Honor.
6 months. If you know only, when do you forego public bidding? What instances under the law?
Public bidding, if there is a failure bidding, nobody bids, or nobody offered to.
That's negotiated bidding.
Yes, we can.
What are the other?
If none of the parties were able to comply, there is no bidder at all. Those were the instances. Negotiated bidding, if the amount is minimal, it need not go through public bidding. Let's say it's only a few rolls of papers, then we don't have to go through public bidding. There are other exceptions but I cannot remember. But if I can, what other instances? But those are some of the instances, Your Honor, that I know of that we have done at our level. The other exceptions I'm not familiar with, probably because we were not able to do it at our level, Your Honor.
Repeat order.
Repeat orders. I think if it involves small volume, we do it, Your Honor.
No resort to it.
Repeat orders, because we have not been doing it, Your Honor. Like computers, other computer parts, big volumes of papers, Your Honor. We have repeat orders, but we do it all through public bidding again. And same thing with services like janitorial services. We do everything through public bidding, Your Honor.
When you do another public bidding, that is not really a repeat order, because a repeat order is a method of procurement from the previous winning bidder. Now, if you know only, what are the conditions in a repeat order?
Repeat order, probably. I'm not sure about it, Your Honor.
You're not sure?
Yes, Your Honor.
I ask these questions because you're the chairman of the...
Yes, for only a couple of months, Your Honor. But I'll try to learn it the moment I get out of this room, Your Honor. But we have some good advisors, legal advisors who handle, who have been with the BAC for so long a time, and we always consult them on these matters, Your Honor.
When you go to the Supreme Court, you will meet a lot of cases about limited source bidding, direct contracting, repeat orders, shopping.
Repeat orders,
like
yeah. It's a
what
good.
you mentioned was a negotiated procurement.
It's a good thing that for the past 6 months or so, I have not been the subject of a complaint
Oh,
So,
you
and
have
so
good
far,
you have good lawyers.
yes, Your Honor. And we are very careful about it, Your Honor. In fact, we try to discuss anything first before we decide on it, Your Honor. And as a jurist, I have not yet encountered any case on public bidding, Your Honor. Issues on public bidding.
What is your understanding of a Swiss challenge?
Swiss challenge, it need not be the lowest bid, but if there is an offer, you have to challenge it. If you can offer a lower bid, then you so be it. I think that was the formula that our president wants to adopt, Your Honor.
Swiss challenge recognized in the Philippines?
In some particular instances, from what I know, but not really as a general rule, Swiss challenge is not really part of the rules on public bidding, Your Honor.
Not yet.
Yes, Your Honor.
Under what law is it recognized?
I'm not really familiar yet, Your Honor.
I'm not familiar.
Huh?
It's covered in the BOT law.
Yes, the build, operate, and transfer law. Yeah, I remember now, Your Honor. Thank you.
It's a jurisprudence. Now you remember
Yes.
you said there is a jurisprudence
Yes,
on that
yes,
when it
yes.
is recognized.
Yes, yes.
That's Suplico versus NEDA.
Yes.
Anyway, I asked those questions because, as I said, we're the chairman of the Bids and Awards Committee. It is recognized under our BOT law.
Yes,
And-
yes, yes.
And there is already a decision on it.
Yes, Suplico.
Actually, it was mentioned in two cases. That will be all, Justice Lopez.
Thank you, Your Honor.
Your excuse.
Thank you, Your Honors. Permission to leave, Your Honor.
Thank you, Justice Lopez. Two o'clock po, kaming hapon.
For the record, the interview process is suspended in the meantime. We resume at 2 o'clock. Thank you.